digest the matters of the motion. The first motion that I want to take up with you is a motion for extension of time with respect to further forensic evidence testing. Certainly the court is aware that there is some forensic testing that has been completed, that there is additional forensic investigation ongoing, and that there is some forensic testing that has yet to be done and is subject to further direction from this court in terms of accomplishing that. And so let me address first with respect to the discovery materials that have in fact been provided. Certainly under the search warrants, there was a return on those search warrants indicating that there was a computer and cell phone seized. Typically it takes a while to get those, to get an examination of those completed. Can you advise Mr. Willis as to what the status is with respect to completing that forensic examination?
Those are being examined. Unfortunately, these were the ones that were involved, and there was a motion filed with regard to an issue on the search warrants early on. We ordered them to stop doing any work on it, and unfortunately that might have put us in the back of the line rather than them just picking up by the time that got resolved after I think a week or two at that point. But they're in the process of actually, they're at the lab to be tested. This is not one where the lab has told us they're not going to test it. These are the labs we're working on, but it's not completed yet. And
at this juncture, does the Commonwealth have any sort of estimate in terms of how much additional time it's going to take to be completed?
We're waiting for the certification and the peer review.
Yes.
Okay. I think our status is we think they've finished the actual analysis of it, but they've got to go through a peer review and a certification by the staff there.
So we're talking about maybe something that's maybe
we're closer
maybe
to
within
end.
maybe within the next 30 days.
Yes, sir. Right. Those are much closer than the other issues.
All right. And then with respect to this motion for extension of time with respect to items that, as I understand it, KSB is looking for some direction from this court in order to complete that testing. Mr. Willis, it does not appear in review in the motion that the Commonwealth has actually had an opportunity to identify with specificity what those items are.
We have a list, but to be honest, the list we have, I need to go through the detective. For example, one seized item had the word miscellaneous beside it. We had, we need to go through them and give some direction to the lab of, we definitely need these tested. We do not need these tested. Probably would be better if I could sit down with a detective. He was out of town last week. We just found this out last week from the lab. The post-evidence custodian at Post 9 called up there and they informed us, I think, Thursday that this had happened. It happened in a Barron County case recently on a murder case over there. They resolved it. They said they just needed a specific order for testing. So we were going to go through and supplement our motion, give defense an opportunity to look through the list and see if there are items on there that they specifically believe should be tested as well, and then have the court draft an order with regard to those items. We should be able to do that within a week or 2 weeks.
So if we set a 2-week deadline for the Commonwealth to supplement its motion with respect to what are the additional items that remain to be seen, that would then give you 2 weeks or so to ultimately review that, and then, as I said, looking at us maybe coming back in about 30 days to kind of see where we are in terms of discovery. Will that give you enough time to respond to that?
Yes, Your Honor.
All right.
The only thing we would add at this point, we would ask the court, and I think Mr. Locke had mentioned this earlier to me, that we would ask the court, it would be a good idea if the court now could, for today, issue an order to the Kentucky State Police not to destroy and to retain all evidence seized, regardless of anything else what we decide to test them. Just an order issued today along that lines would be helpful.
And am I correct in my assumption that all of the evidence that has not been tested yet would not be necessarily identified in the discovery that I have received. In other words, I don't know as I stand here today what evidence exists that has not been tested. Is that correct?
Everything that was on the evidence recovery.
That's
Yes.
right. I believe you have a list. It would be in your written discovery. We did provide that, but when you look through the list, to be honest, we're going to need to give you more information because, as I said, there were 1 or 2 items that were listed with the word miscellaneous beside them. You would need more information as to where that was seized, where it was found, and what type of item it is to be.
And your supplement will identify the items that have yet to be tested.
Right. And actually, I think you have. Did we give them the highlighted version? Okay.
No.
Yes, we'll do that. We will do. We'll list through, and we've already given them a list of the items at the lab. We will go through and list items. These were tested. These are being held.
Okay, and so we'll have 2 weeks to respond to that, and so again, with the target date of maybe coming back in 30 days. We then have 2 additional motions. Is there anything else we need to address on that motion on behalf of the Commonwealth this afternoon?
No, Your Honor.
Anything on behalf of, all right.
No, Your Honor.
All right. So then let's look at there is a general motion that the Commonwealth has made relating to short-term pretrial publicity regarding potential impact on venue for the trial, and as I'm going to say, a subset of that motion is a motion basically to prohibit the copying of photographs and video recordings. Mr. Locke, have you had a full opportunity to review those motions at this time?
I have not, Your Honor. For the record, I received both the motion that we have already addressed regarding the forensic testing and the motion on the short-term pretrial publicity. I received those simultaneously with the receipt of the discovery yesterday afternoon, and then the motion to issue limitations regarding the copying, I received that today.
Well, let me start first with, I'm sure both counsel are mindful that the Supreme Court has actually issued rules with respect to counsel's obligations with respect to trial publicity. And there is, of course, not only is the Commonwealth obligated under that rule, but also a separate rule with respect to prosecutors' duties. And ultimately is the purpose of that rule is, of course, to protect and preserve the integrity of the proceeding, to ensure that there's not a substantial likelihood of materially prejudicing an adjudicated proceeding, and of course foremost is with respect to the defendant's right to be tried in this court as opposed to being tried in the media, and certainly underscore that the discovery materials that have been provided to the Commonwealth may ultimately be admissible in a court of law, and ultimately they may not be, and certainly to protect and preserve whatever evidentiary rulings the court may subsequently make with respect to those discovery materials. Certainly you have to balance basically the pretrial publicity that a case of this nature is going to garner, and certainly, I mean, this case, of course, is the most difficult case that any of us will ever have to deal with, and certainly in our careers. With that said, at the same time, certainly this court is mindful of the strong constitutional limitations with respect to prior restraint of speech, and that ultimately, in order to set limitations, ultimately the court has to balance the competing interests. With that said, what I'm going to suggest to council is this, is that, first and foremost, that Mr. Locke needs an opportunity to review these materials, to digest those materials, and then certainly have an opportunity to review those materials with his client. I want him to have an opportunity to then, ultimately respond to the Commonwealth's motion based on having done that review. Again, balancing the competing interests that are present. But with that said, that certainly, particularly with respect to the photographs and the video recordings, that there's no way to unring that bell. And certainly, given the sensitive nature of those photographs, what I'm going to suggest to council at this time is that we put a temporary restriction on any photographs or recordings being released until you've had an opportunity to review them, and then we'll have an opportunity to come back and have further hearing on that. That restriction would extend to anyone beyond beyond the attorneys, and so certainly to the extent that you have to the extent that you want them reviewed by another individual, by someone else, and again, I'm not trying to second guess you in any way. Again, taking into consideration the nature of the photographs, that we come back and be heard on that. But I'll hear, again, whatever response you would like to make at this time, Mr. Locke.
I have no objection to that course of conduct, Your Honor.
All right. Okay. And so what I'll do is I'll sustain the Commonwealth's motion with respect to the limitations on copying the photographs or the video recordings pending further proceedings before the court. I'll defer ruling on any additional limitations with respect to pretrial publicity. Taking it within the scope of the Supreme Court rules until we have had further opportunity for counsel to review those. And oftentimes, it's not uncommon with cases of this nature that counsel ultimately are able to come to an agreement in terms of what, what sort of limitations are going to be placed on, again, to protect the integrity of this proceeding, and ultimately the jury pool, wherever that jury pool may subsequently be selected from. And so, counsel, what I'm going to suggest that we do is this, is if you will look at your respective calendars, that we maybe look at a date about 30 days out, taking into consideration the Commonwealth schedule the 24th and the court schedule the week of the 31st. That would throw us over into looking at maybe September the 7th as a
We don't have any schedule on the 8th or 9th yet, do you, Your Honor?
no, that is KBA law to update for Bowling Green, and typically we don't schedule things.
We have no
like that.
objection to the
Does that
7th.
work for you? All right, and so what we'll then do is we'll go ahead and set this for a supplemental status conference.
Were you looking at morning or afternoon, Your Honor?
We'll do it at 1:30. Again, I think that that works better with, of course, the court schedule, because, of course, we also have district court going on, and so in terms of trying not to overload our security personnel with respect to moving people in and out. All right. And so at this juncture, Mr. Willis, is there anything else that we need to address on behalf of the Commonwealth?
The only thing, Your Honor, is if there are any other matters that the Commonwealth of Defense want heard on the 7th of September, would you like a date to have them filed by, so we don't walk in at the last minute?
If that could be filed by the 2nd, if that could just be filed by the 2nd, that would be the Friday before Memorial.
Yes, sir.
Anything further on behalf of the defense?
Nothing further, Your Honor.
If it's possible for you to issue that order for the KSP not to dispose of and to hold the evidence, that'd be great. We could have the officer get it up to them as soon as possible.
It may not be done by this afternoon, but it'll be done tomorrow.
Thank you, Your Honor. Nothing else.
Mr. Law, do you need to speak with your client further at this time?
Just for a moment, Your Honor, please.
All right. We'll go ahead and put Mr. Madden back in the conference room. And then if I could see you just for a second, Mr. Henson.
Yes, ma'am.
I'm going to ask everyone to remain seated at this time, just for a minute.
I'll just need a moment.
Okay.
Very brief.
Okay, you go ahead. They've got them set up.